Hello, it's Charles Goldstein. I'm here with Daniel Anzanello. He is a marketing, what we call maven, in other words, an expert on marketing. They're a little looser in what they can call themselves in the marketing area as lawyers.
Sorry about that.
And I'm Charles Goldstein. I've been an attorney since 1987. Had my own firm for about 20 years and was responsible for the marketing of the law firm. So today is for CLE credit. So please provide your full attention, of course. Turn off your cell phone and any other distractions you may have. We'll be sending the course number for your credits within 24 hours at the end of this seminar. And if you're watching it as a replay, you'll be able to see that on the website as well. But we'll let you know what that is once you've signed up. We'll make sure to inform you again. And the next 45 or 60 minutes will hopefully make a difference to you in your future in marketing, because what we're going to tell you is critical information, including on local developments that have been very important for the advertising area relative to lawyers and relating to their ethics as well. So today we're going to cover advertising regulations under the Minnesota Rules of Professional Conduct. And they did go through some drastic changes. Some wouldn't say drastic, but they can have some drastic ramifications. And also about how to find your clients online, and rather how they find you online, and trends in how they're interacting with lawyers when they do so. And Dan will especially be addressing managing your online reputation so that you can make sure that your image and your name and your information out there is remaining effective and well done for the clients who are trying to locate you, or potential clients, of course. Okay, a little more background on me. I've authored more than 25 articles for Hennepin Lawyer and other publications. I administered and took care of all the marketing for my own law firm for about 20 years. And I have, in that process, creatively initiated and executed a variety of marketing tactics for my law firm in that process. And now I'm currently reinvigorating myself as an employment law attorney, which I've been doing for about the past 6 months. It was always an area of passion for me. So I'm turning that into my area of focus. Dan.
Awesome. So I've written the Legal Marketing Handbook and spoken at various events across industries, built an SEO optimized over 225 websites, and launched over 25 brands. And now I've done CLEs in 2 different jurisdictions. And by the end of this year, we'll be picking up Texas as well. So legal's been a very good part of my agency's portfolio. And this is something we look at as a way to give back to the community that's been good to us. A few of the clients that we've worked with, both within legal and without, certainly firms, but also even a practice management, Zencase, and have done that for 8 years now. So quite some time.
All right. The Minnesota Rules of Professional Conduct relative to advertising have changed as of September of last year. And actually, it was recently revised, rather the treatise by William Wearns on the Professional Responsibility Board's site and available through the Bar Association, has recently implemented the revisions to that treatise so you can read more in detail all kinds of commentary about these new rules. So they've been colloquially referred to as the advertising rules and have undergone a lot of revisions. Most notably, the word advertising is now no longer in the rules. And the ramifications of that are several, but some of the same underpinnings still remain valid and effective for those rules, mainly 7.1 and 7.2 under the Rules of Professional Conduct, and 7.3 as well.
So a key to keep an eye here, and something that we're going to actually mention twice in this presentation, is that unfortunately, for those of you in the legal profession, certainly there's a duty to manage the folks under you and make sure that they are trained adequately. And it's various ethics topics, which include confidentiality, conflicts of interest, communication requirements, etc. Now, the interesting thing here is in ABA Formal Opinion 501, but also Minnesota has adopted this. Even if it's an outside firm where you don't have direct control of those employees, you do have a duty to manage them to the ethical standards of the profession. So in today's presentation, we're going to go over really mostly Rule 7. And previously that was 7.1 through 7.5. But as you'll note, 7.5 and 7.4 have been deleted. And those primarily had to do with calling yourself a law firm or what the firm name is, letterhead. And with that, you do have a disclosure requirement. So you must identify the individual lawyer or the law firm that is putting out the communication, the advertisement, or solicitation. That's not new. What is new, though, is that now contact information must be included. We didn't find anything when we did our research on the specificity of do you have to have a email address, website address, phone number, and mailing address. Obviously, in many cases, that would be difficult to put all of those out there, but there does need to at least be some sort of contact information provided in those communications.
I recommend, of course, at least name, telephone number, email address.
Something that makes it easy to get in contact with you.
Now, here's one that is nice, especially for lawyers who are doing any kind of advertising, such as newsletters. Some attorneys are still writing letters to potential clients, to criminal clients, etc. And those have always been having to say advertising material at the bottom in prominent print. And the board now has decided that it's no longer, that in the Supreme Court, that it's no longer required that we state advertising material at the bottom of those items, such as newsletters and letters.
It's kind of nice because it used to really demean the power of that communication, even if it wasn't explicitly for advertising.
Yeah. So communications under 7.1 remains the same. We still have to be very careful about material misrepresentations of fact or law, and not omit any necessary facts to make a statement true. Dan and I were talking about some of the possible things that might be said that could constitute a material misrepresentation of fact or law. I don't think any of us are likely to do that, but omitting a necessary fact could be a little trickier. Give it careful consideration, run it by your colleagues to see if anything in your communications is omitting a necessary fact to make the statement true, especially when one is advertising their abilities and their potentialities in a certain area of law and to make a certain recovery. If, for example, a lawyer says, I've never had a verdict less than X amount of dollars, maybe they've only had one verdict and it happened to be that amount of dollars. That's not good. It could be misleading to the client who thinks that you've had many verdicts and that's the lowest you've ever done.
Yeah, that feels like a pretty necessary fact to make the statement true.
Now, of course, we still have the requirement. We may not predict, promise, or guarantee success. And that gets a little trickier, as Dan will talk about, relative to third parties running our marketing. For example, Super Lawyers by Thompson Writers. Are they predicting or promising or guaranteeing any certain success by calling some of us super lawyers? But no matter what the case, specific results can't be predicted or promised. I'd like to make the joke with people. They ask, what are my odds to win this case? And I'll say something like 72.4%. And they'll say, really? I believe it. And I said, no, it's like predicting the weather. We have to be very careful not to lead them to believe that their results are going to be within even any certain bracket of success. We have to say that the results are going to be dependent on a lot of factors. And those factors, until they finally come together, won't allow us to know what your result will be. Nor can we give aspirations. You'd like to have $1 million reward in your case, and you lead them to believe that's what you're actually going to be able to achieve.
So a couple terms or things to mention that will help protect yourself from false or misleading statements in any of your communications out there. Past performance is not a guarantee of future results. Each case has its own merit. 7.2, lawyer services. And this is the section that was previously titled advertising. As we mentioned before, a lot of the advertising language has been replaced, but you cannot pay for referrals. However, you can pay the reasonable cost of advertising. So if it's reasonable to run an ad in the newspaper for a couple $1,000, that's fine. But if you're overpaying or there's something else going on in that advertising that you're doing, you could put yourself in risk. You can pay the usual costs for a legal services plan, and you can pay for a legal referral plan. If you need more information on that, go ahead and read Rule 7.2, Comment 6.
Nominal thank you gifts are now allowed. Now, what's interesting about that is it doesn't really refer to what nominal means. In the Humiston article, she refers to gifts as typically being something more than a thank you note, but something less than maybe a token gift card or something. And so I made a call to the ethics board and asked for an advisory opinion What does that mean, nominal gift? If someone refers you a case that allows you to bring in $1 million, what happens to the amounts that are allowed? And I remember once I referred a case that involved a life insurance policy, and the take was huge on it. And so the firm that I referred it to decided to give me a check for $10,000. It's a true story.
Wow.
And I didn't take the check. I thought that because I was not on the retainer agreement with them, and in fact I had already charged hourly to this person before the referral, I had to turn back the $10,000 check. And so because, hold on, Ian, calm down. Those are, so nominal probably shouldn't be more than $50 to $100 based on the advice that I was given in an advisory fashion by a fellow over at the ethics board, that should be the max given. So it doesn't matter if you refer a case that brings in $100 million, you better stick to something that can be referenced as nominal in any situation, which according to this person at the ethics board in an advisory fashion said $100 is probably your max to give. Now in the past I've gotten gifts at the holidays. I remember one divorce lawyer I'd sent referrals to, due to conflict, sent me a stereo receiver that was very nice. But that one I didn't return back. Nice wattage. So that one probably exceeded, but query, what's the responsibility of the receiving party? If you receive a gift from someone for making a referral, do you have to turn it back? Do you need to go out and have it valued and see if it's worth more than $100? I don't know, this makes things kind of foggy, and I think they're going to have a hard time enforcing this, given that there's really no definable amount that makes it more than a nominal gift. That one we covered, special language being moved. Let me just check my notes here for a second. Some of you might remember there was a debate that was going on between the State Bar, the Lawyers Board, and others as to use the term specialist or the phrase certified as a specialist. And the court continued with the status quo but moved the text from Rule 7.4 to Rule 7.2. Now, of course, we can get certified as specialists by the Bar Association's testing and exam procedures in certain areas of law. But there are also a very limited number of other organizations that they authorize to call yourself certified. And I looked at that list, it's quite short. So you have to be very careful using the name of a certification organization, calling yourself a specialist of any kind. But my query is if you call yourself an expert, or if you say I have expertise in, does that portray yourself as an expert? I think that's another gray area, Dan.
So solicitation.
Okay. A communication initiated by or on behalf of a lawyer or law firm directed to a specific person whom the lawyer knows, reasonably knows, should know, needs legal services, that offers to provide those services. So relative to whether there's been changes, there are several changes to Rule 7.3 that are worth attention. The rule now includes a definition of solicitation in Rule 7.3 as a communication initiated by or on behalf of a lawyer, and that's the one we're just reading on the screen. And that tells us solicitation is specific to a communication that is directed at someone you know or should know needs a lawyer and includes an offer to provide legal services. Now, Dan and I were talking about an example. What about LinkedIn? You could go, for example, as I might as an employment lawyer, use one of their tools and find everyone who was at Wells Fargo if Wells Fargo had a recent layoff and send them materials that relate to layoffs or severance packages. Now, would that be intended to reach people who would necessarily need legal representation, or do they just happen to be people who are laid off and might need severance help and they deserve to get that kind of guidance? So I think there's also some gray area there. And now in this age of the internet and social media, putting information out broadly is not necessarily soliciting one particular individual or more. It's spanning information out to the general public that might be helpful to them.
Cool.
Okay, solicitation of clients. Beyond the legal ethics standards, we also have criminal penalties. Pardon me, that has not gone away. And so be very careful that you haven't done anything that would cause you to be accused of solicitation that amounts to having a runner or capper, someone who is paid to go out on your behalf to locate people who are in need of your legal services. There's still a misdemeanor on the books for that. I doubt many people are sitting in jail for this as we speak. But you may want to write them a letter and see if they need legal representation for that criminal action they've done by trying to solicit clients. Okay, so here is a slide we just forgot to update because we noticed on the last couple of days that the Werns.
No, we updated it.
Oh, it was? Okay, they're seeing
Sort of.
what I'm seeing?
Well, yeah, what they're
Okay.
seeing is the slide was written that the Werns Treaty had not been updated. But between the time we had this approved and the time of today, it was updated.
You should be an attorney, Dan. So you're playing technicality. When we submitted this
I learned
to the
from the
board,
best.
when we submitted this to the Sealy people, that's the way the slide read. Now, it's no longer the case. The Werns Treatise has done an excellent job of giving us an update on that. And if you want to look at the Werns Treatise with regard to the pages, it starts in about 1275, and it does a very extensive analysis of all these changes and the implications of those changes for us as attorneys and for marketing people, such as Dan, who are so conscientious as to learn these rules. Dan basically reads himself to sleep at night reading the Werns Treatise.
Oh no, this is how I wake up in the morning.
I go to sleep with it. It works better.
That's exciting stuff.
No offense to Mr. Werns. Okay. So keep in mind also, if a person might already have an attorney, and Dan and I were talking about the example, you reach out to people on LinkedIn who might have the issue you're looking to help. What if they're already represented in that issue? So even if you're broadly spanning out communication on the internet, you're likely to reach people who already have an attorney on the issue. And of course, one rationale for this rule is they don't want people second guessing their own attorney by somebody else stepping in. The person might think, oh, Charlie's got better advice than the guy that's actually technically advising me. So it's always a good idea to append to this statement, if you already have retained a lawyer for this matter, please disregard this communication. And especially if they say, hey, I already have an attorney, well, you better step off quick.
Mm-hmm.
But now solicitation is revised in a way that's really important. Now that rule only, or that phrase rather, definition only applies to live person-to-person contact, which can include a Zoom and a phone call. But look at the things that it doesn't seem to apply to. Text messages, Google ads, forums and chat rooms. So I think they probably found it, with the Facebook messages, they probably found it too hard to monitor and control lawyers sending out all these various types of communications to random people, so to speak. And so that solicitation is much more narrowly defined now to the live person-to-person contact, which is really helpful to lawyers trying to get out the general word about things like severance agreements, what's involved, what you can do about them, etc.
And just a thing to note, really an operational consideration is when you are in any of these types of forums, it's very easy to be communicating with a person who's not in Minnesota. And you do want to make sure that there's clarity on, okay, what applies here. Obviously, we're not suggesting anyone's going to practice outside of a state where they're licensed to do so, but it's really easy to think you're talking to somebody in Minnesota and they happen to be in Florida, and that is something to protect yourself against. Excuse me. So a couple resources to refer to on this are, again, the ABA model advertising rules. Those were adopted in 2018. Minnesota basically adopted those rules last year in September. But then ABA did also issue a formal opinion 501 on solicitation, which we really think is worthy if for the non-attorneys that are doing any communications on your behalf. That's a really good document. It's only 9 pages for them to review and make sure they're not in ethical gray area. And if you'd like, you can just email us, and we'll get links of those for you. Keep in mind, these rules do apply to everyone working on your behalf, whether a statutory employee, whether you've retained an outside firm or an agency or whatever. The supervisory, if a violation occurs, the supervisory lawyer has violated rules 5.3b and c, and has also engaged in misconduct, 8.4a.
One thing Dan and I talked about, if I may interrupt for a moment, one thing Dan and I talked about is, are you supervising people who you've hired to do marketing? So for example, I hire a marketing person such as Dan, and he gets creative and does some things. Maybe they are spur of the moment, and they happen more quickly than I can get tracked back to. Maybe a change in the web page, etc. Am I supervising attorney of him, or if he's not my employee? What if I'm listed as a super lawyer with Thomson Reuters, and Thomson Reuters decides to change the way they're administering super lawyers? Am I responsible? Am I supervising them because they are actually carrying out my wishes to market myself to the public? And so that's something to be cognizant of. You probably want anyways to know what is a company like Thomson Reuters doing to market you, whether it's through FindLaw or SuperLawyer, or whether it's Lexis or anybody else that's marketing you. What are they doing that might infringe upon some of the rules that are out there?
Great point. Great point. Let's talk about reviews a little bit. And again, this does go to tactics that firms use, as well as outside agencies, etc. And this is a fascinating piece, because this research came out in 2018. So if anything, these numbers have grown. But 84% of people out there will trust an online review as much as a personal recommendation. So specifically, the practices that rely on word-of-mouth referrals, that sort of thing, the reviews are actually catching up, if not surpassing, since they're ubiquitous, what a referral would do to help you get your clients. And 87% of people, again, this is back in 2018, will need a business to have 3 to 5 star ratings before they're going to interact with them. The unfortunate news for the legal community is, in our own research, we found it's 4.2 star rating that is a tipping point. And at that rating, typically the call volume, text messages, inquiries, etc., will double for a law firm.
Wow.
Or, said differently, if you go below 4.2 stars, you lose half of your referrals, or when people are researching you, they're going to decide against you. The other thing that was disappointing or advantageous is 90% of consumers need to see 10 reviews or fewer before they decide that they can trust you. So if you haven't garnered that many reviews, that is an action that anybody of competence is going to suggest for your firm, as well as 2/3 of people will form an opinion with 1 to 6 reviews. That's all they need to see.
I think you said 90% or fewer. I think you meant 90% or more for them to trust you.
Okay, excuse me.
Yeah, don't try to get as few as you can. Get as much as you can.
My misspeaking. 90% of the people that are looking at a firm's reviews will be satisfied with 10.
Okay.
Now, the key here, and what we counsel anyone that we work with, is just do a search on your own firm. And what you'll notice is the areas where you should be focusing on getting those reviews. Obviously, ethically, and we're going to talk about that in a moment, but in a perfect example here, it could be Yelp, it could be the Better Business Bureau, it could be Bird Eye, but this is going to change for every law firm, for every practice, and that's where you should spend your time. Also on the right-hand side here, Google reviews. Typically, that's the number one, just because it's got almost 50% of the real estate on this page.
Okay. Now, reviews must be real clients. It's fine to request reviews, and they need to be. There's a need to be across platforms. Now, this slide we may have modified that a little bit. We should have modified it a bit because the first two, of course, are requirements.
Mm-hmm. Ethics requirements, correct? Yeah. Yep. Good point. Good point.
And the third is just from a marketing standpoint, is that right down what they need to be. They need to be across different platforms. Now, when I was practicing divorce and I had a lot of divorce testimonials, I would put in full first name, but just the last initials. People weren't identified as much as they would be if they were identified by first and last name, which is, of course, pretty much completely. And so I was wondered, by putting in just their first name and last initial, was that enough to give them credibility in those reviews? Where nowadays you often see first and last names, but not in family law matters. Mm-hmm. Yeah, what kind of advice do you give to clients when they ask you, should testimonials always be first and last names, or to preserve confidentiality, do you want to just go with the last initial? What are your thoughts about that?
Whatever that client is comfortable with is probably the best recommendation. The picture and the first name are typically what give weight to a review when someone else is looking at it and deciding if it's real or not. But take what you can get to start. And that actually is a wonderful segue. Sorry, I'm cutting you off, but and here's where we were looking at a local firm, actually a Wisconsin firm. We're not throwing anyone in Minnesota under the bus. But these are perhaps flags that can help you get a sense of whoever's getting reviews for you, what they're doing, what their tactic is. And by itself, there may or may not be anything wrong. But if you see a pattern of this in somebody's portfolio, there's probably unethical behavior happening that will get you into trouble. In this case, the reviewer was Jim Smith. That's a pretty vanilla name. Certainly, there's a lot of Jim Smiths out there, but it is something that grabs somebody's attention. Right below that, you'll see one review. So whoever this Jim Smith has only left one review in all of his history.
I wasn't even aware that meant that. The one down here by the thumbs up means
This is a like, but up here it says one review. That means this account, this individual has only left one review.
of anyone.
Of anybody.
I always thought it meant there was just one review for this firm.
No.
Okay.
So in this firm's case, there was actually over 200 reviews. So it became very apparent that some sort of cultivation was taking place.
Some Jim foolery.
Well, I mean, it could have been
Well, it's
ethical,
not
right? I mean, bankruptcy firms, and that's not what this one is, they're going to have high volume. But if it's a high volume of one person reviews, then that's to me a sign that what was your word, tomfoolery?
Yeah.
So in this case,
Jim foolery.
Jim foolery.
But also, he said counsel was unparalleled. That makes it sound so extreme. It's almost unbelievable.
Exactly. And there's very little detail about the matter, which you typically will see. Obviously, in some like criminal, perfect example, you might not have a lot of depth up to that context, but this was lacking. So when we went through, we saw about 20% of the reviews were in line with this, which should be a red flag to anyone out there who's working with the review process. So in asking for those reviews, the reviews are testimonials. As Charlie mentioned early, it is okay to ask. You cannot pay for them. And not only are there ethical violations on that, there's actually FTC violations, and most platforms don't allow it. Even, hey, a gift card, a $5 gift card, hey, would you leave me a review, and here's your Starbucks. That is not allowed by the platforms nor FTC. Another thing that, without getting too far off of the ethics, but the FTC and other rules will come to play. If you do any type of curation of good reviews only, so this person's going to leave you a 5 stars, so you ask them, but you don't ask everyone else, that's actually technically a violation. I haven't seen anything in the ethics rules on that yet, but I would imagine that's coming.
Dan has mentioned a few times the FTC, Federal Trade Commission, right, Dan? Mm-hmm. And he's given me some education that I really hadn't gone to their rules when it came to marketing to see what needed to be accorded with. And he's brought up a number of things that they required that we need to be mindful of. So I recommend anybody go to the FTC rules and see which of those are applicable to lawyers. That could even be a little CLE in itself.
Yeah, they notably just slapped I think it was a $600 million fine on a supplement company for juicing their reviews on Amazon. So
it wasn't me.
They're very you're not a supplement guy that I know of.
You scared me, Dan.
As we mentioned here, not permitted to pay others for recommending the lawyer's services, and quite arguably, if you're hiring a firm that's putting up these reviews, especially the non-real ones. Then you've crossed that boundary.
You're being an online capper.
Right, and that's Rule 7.2, Comment 2. So managing your good reviews, and this is again the ethical way to deal with not only good, but the bad reviews, is one of the most common questions we get is, what do I do about these bad reviews, right? Dan, you told me I need to be at 4.2 stars. I'm at 1 star. What do I do? So with good reviews, you always want to respond, because that's going to give the readers, the third-party readers, some context into what it's like to work with you and your firm. Ah. And it can be as simple as, thank you, pleasure to work with you, move on. Bad reviews, just for context. 2 common sources really seem to be, right, it's somebody you told they just don't have a case, which is sad, right? Because you're doing them a favor. There's nothing here. But we see a lot of reviews coming from that. And then typically the other party in the matter, so divorce attorneys tend to get a lot of the brunt here, so the opposing party tends to leave a bad review for the attorney. So how do you manage that? We wish you could just click on the button that says flag this review, and it's an unfair one, and Google or whomever deletes it. 80% of the time, it does not get deleted. So it's worth trying, add it to your workflow, but it's probably not going to get there. What you do need to do is respond back to the post, acknowledge the issue, apologize, but especially if it's not your fault, don't take ownership of it, right? Apologize for the feeling, provide an explanation if necessary, and ask them to contact you directly. That's important because it diffuses the bad energy of that review. It's like, okay, they're trying to get to a resolution here, but the other party is just upset. So here's a suggested response. There's really two lanes here. If this person is not a current or past client and you can't get that review deleted, then just say, hey, dear John, I don't have a record. We don't have a record of you being a client of our firm. Please call us. That's all you need to do. Don't engage. Don't defend yourself. Don't do anything like that. Whatever you do to try and defend yourself actually makes you look worse. Now, if they were a client, you do need to consider privilege. So respond back in the same channel with some compassion and honesty and invite them to contact you directly to discuss. And the key here is to move that conversation out of the public forum into a private one. Dear John, sorry you're unhappy. Not everything goes the way we hope. Please contact our office. We'll do anything we can to work towards a satisfactory resolution given the circumstances of your case.
Could I give one example?
That'd be lovely, yeah.
Lighten things up a little bit.
Yeah.
So I have recollection many, many years ago, early 1900s, I was going to say. Not quite back that far. Going back to about 1989, 1990, I was in a firm and had a divorce case, and the other party who was upset came to find out that I had played golf in a tournament with one of the judges in the county who was on the case.
Oh, no.
And so he complained to me and the ethics board and anybody else you could talk to that I had gone and played golf with the judge in the case. Well, of course, I didn't call the judge to play golf. We happened to be in the same local bar association tournament. So there's an example of where the opposing party can jump up with a review that isn't, or I don't know if you call it a review, but a complaint that really isn't justified under the circumstances, yet you still have to respond to it and diffuse, especially for those people who might read Goldstein played golf with the judge in the case, and they might say, wow, this guy is really dishonest.
Or he's really good? I don't know.
That was a smart thing to do, I thought.
You did bring up a fantastic point there. They went out and told everybody. So we do see a pattern when there's a particularly upset party. It's kind of like the old restaurant, right? If you like the restaurant, you might tell one friend. If you have a bad experience at a restaurant, you're going to tell 10. We do see the same thing in online reviews. So if you get a bad review on Google, on Avvo, on whatever, make sure you have somebody checking the other platforms and doing the exact same thing. Other popular channels that are worth talking about and could introduce some ethical considerations are what we're going to call the video sharing sites. And in this case, everyone's familiar with YouTube. TikTok, who knows if we're going to have a TikTok here in 1 to 2 months. But then Instagram, Vimeo are some examples of that. And of course, that crosses the boundary of social media and video sharing sites, but they're both important. And the reason for this is YouTube is the second largest search engine on the web and a particularly important one for legal. When somebody has questions or they're researching their legal matter, online is a very accessible way to do that. And YouTube in particular, be it a legal matter or whatever someone is researching, is where a user will tend to go to learn more. So be it, how to fix something on your car or how to deal with a labor issue, whatever it may be, YouTube is a huge one. But TikTok is really jumping in behind. And there's going to be a tendency for anyone who's in the communications field for you to suggest TikTok. And a perfect example is the labor lawyer on TikTok. Those views are over 200,000 per video that this gentleman's getting. And in my world, that is easily a 5 or 6 figure advertising budget. And this guy, whatever he's doing, is getting that type of exposure for free. Now, where do video sharing sites fit in the whole ethics hierarchy? Is it a communication or is it a solicitation? So far, if your video is not live, so this doesn't apply to like the live streams, but if it's not live, if it's pre-recorded, it's going to fall more in the communication bucket, especially since they're typically not direct, right? So this, again, doesn't apply to your Zooms or if you're live chatting with somebody on Facebook, it's not a direct communication, so it's going to fall more towards communication. But if you do add a call to action at the end that sounds like a solicitation, then you might want to tread a little more carefully, right? Call me about your case right now might not be the language you want to use. Now, also do keep in mind it is going to be subject to other rules. This is a global platform, let alone bigger than just Minnesota. So if a person on the other side is in a jurisdiction with tighter rules than us, that could be an issue for you. And as always, make sure that it's clear that you're not giving legal advice. It's informational or even educational or entertainment.
One thing I've been dealing with is what kind of YouTube videos to make. I've made some YouTube videos, and I'm telling to someone now who says to reach out to the younger population, you need fast movement, you need humor, you need constant change up, you need to be edgy. And so I'm struggling with what are the ethical rules that surround edginess and humor? I don't think we have those yet. You can't be too funny, that's for sure.
Yeah, stop being funny. Well, I think that's the content that we wanted to cover today.
I think it is, Dan.
Let's see here. Cancel it, and alrighty.
Are they locked into mutes?
There we go. We'll go ahead and allow an unmute if anyone has a question that they want to ask.
Are they still here?
Hi, I do have a question on the Instagram end. So, I mean, you guys talked about TikTok and YouTube. Do those same types of rules apply, I guess, for Instagram posts? And like, if you are, trying to create a brand, trying to create a presence for the law firm, right? Like, to create informational content. But even if at the end of that, like, should you avoid putting that, contact us for more information, or?
I would, and Charlie may have a differing and probably more valid opinion than mine. I would suggest a little more vague. Instead of us, make sure you contact a qualified attorney if you need specific guidance on this type of matter or case.
I think that's good advice from an ethical standpoint, but also in my area that's consumer oriented and what may apply to some or all of you, I avoid that because I don't want somebody's full story splayed out in an email or a message online to me, because now I'm responsible to have heard all of it. Let's say they have a deadline tomorrow, I've got all the facts in my hand from what they told me and I've not been paid anything, and I may have no time to respond timely to them and their deadline. A fellow just came to me a couple of days ago and he had a deadline to sue for an EEOC letter. The Employment Opportunity Commission gives you a certain number of days to sue, and so he didn't leave me enough time, and I was still trying to make the deadline until I realized that the EEOC and the Department of Human Rights both said he wasn't providing any documentation they requested for. Oops, just dropped her. That they'd requested. So in that case, I had taken him into the office and I gave him some counsel, but that's when he poured all the documents at me. He paid me at that point. But at least I got paid and I had time to decline. But if you allow people to send you a lot of information about their case, not only they can really box you into a corner because you have almost a representation situation in hand, you've gotten their feedback on what's going on with them, you're in a position where you have to respond, and you may have to respond for a couple of hours to cover your bases, even if you're going to decline a case. That's my take on it. It sounds like a good idea because the person buys in to communicating with you.
Oh, go ahead, Rachel. Sorry about that.
No, I was just going to say thank you. That's
Sure.
helpful. And I guess a follow-up on that too is something we're considering is whether we keep our comments open on Instagram or not. Like, we want to allow publicly engage and be responsible for monitoring that. With that sort of, I mean, people commenting on Instagram, does that kind of feel like the leaving a review and like some of those ethical goals, right?
Mm-hmm.
Yeah.
You're talking about having somebody reply on your behalf on the Instagram, or somebody just randomly does it?
I guess we were considering more of like if people, we're working on building our, cannabis law presence here in Minnesota, and a lot of it is controversial at this point, right? And so some of if we have educational posts and they create more controversial content, or if they leave questions open for people to answer, and people start responding to that, we're not sure what our obligations are to monitor people's comments.
Well, sure, it would be wise to put a disclaimer. Any comments to our comments are not items we're going to respond to. I'm not sure I word this exactly, but I'll think about that. If you want to communicate with me after the seminar, I'll think about what might be a good disclaimer for that sort of thing, because I am hyper CYA, and so I would do whatever I can to make sure that there's at least a disclaimer for a person who takes that kind of approach.
Yeah, that would be great. Thank you.
Great. Any other questions? All right. Well, thank you everyone for attending. You'll be receiving it's the course number that we need to send for them to register their CLEs
Right.
within 24 hours. And if there's any other questions, please feel free to reach out to myself or Charles
Yeah,
directly.
there's some extra time that has not been used, so feel free to use that time to contact us after the fact here. And Danny actually pointed out to me that the CLEs formally are 50 minutes or 55 minutes per hour.
Mhm.
This has been your therapeutic hour, I guess, Dan. Not for you, for the people involved.
I'm told often that I need therapy, so it's okay. All right. Thanks, everybody. Appreciate your time.